is Michael Popok, and guess where you are? The new Legal AF MTN YouTube channel, another pro-democracy channel in collaboration with the Midas Touch Network. We're just spilling over with legal analysis and commentary at the intersection of law and politics, so we just had to form a new channel, and we're glad you're here. Free subscribe. Take a minute and help us build this pro-democracy channel. Judge Chutkan just gave Donald Trump sort of a win as it relates to the D.C. election interference case. There's a separate case, if you will, a separate piece of paper that was filed by 21 members of the media trying to get more of the sealed and redacted documents filed by the special counsel against Donald Trump in the D.C. election interference case. And so recently, the judge took one look at the 165 pages and looked at the blackout, we call it redaction, that was proposed by Jack Smith and said, yeah, that looks about right. And we got it. There wasn't a lot of redaction, but there were certain names. You know, there's 77 different people that are listed there. I would say about 2/3 of them we can figure out on the fly, but the other ones are a little bit harder. And, you know, the media doesn't want to work that hard. So they want a less redacted document. And they cite to public access case law, constitutional case law under the First Amendment, which gives the media the right to access. What I like about this hot take is it allows me to do a little bit of a teachable moment about the right of the media under our First Amendment and freedom of the press. Because oftentimes all you associate the media with, not on our audience, but in general, is Donald Trump's ridiculous refrain of enemy of the people. You know, the enemy of the people, the enemy within, the enemy that he wants to use armed troops on U.S. soil, turning the turrets of their tanks against American citizens as he marches them into internment camps. This is just in the last 48 hours, guys, folks. You know, the fact that I got to talk about the Insurrection Act, martial law, the suspension of the Constitution, suspension of writs of habeas corpus, so you stay in a dark, dank cell without seeing the light of day in a courthouse in a long, long time. No due process. I got to talk about the Alien Enemies Act. I mean, I'm dusting off books from my law school, you know, chapters and horn books and treaties just to get prepared to do my hot takes and my analysis because of the threat of this potential presidency. So I like talking about, in a healthy, functioning, democratic, constitutional republic, the role of the media in exercising their First Amendment rights to keep the government honest. In fact, one of the cases that they cite in this brief that the 21 members of the media coalition, which include the usual suspects, CBS and Gannett newspapers, NPR, National Public Radio, NBC, the New York Times, you know, other news media alliance, you know, Midas Touch would be part of that too, Legal AF. They try to remind the judge, Judge Chutkan, about a decision as recently or back in the Aaron Burr times. Everybody loves Hamilton on Broadway. And that was a real story, okay? And so here's the quote they used from one of the cases that details the right of public access to the media under the First Amendment. Long ago in the celebrated trial of Aaron Burr for treason, it's a good reason, he also took a shot, killed Hamilton. For example, Chief Justice Marshall, who, let me just stop there. Chief Justice Marshall is the Elvis Presley of the United States Supreme Court history. He is the fill in the blank, Michael Jordan, LeBron James, Will Chamberlain, whatever you want, of constitutional history. If it wasn't for Chief Justice Marshall, who I spent 30% of my law school class learning about during constitutional law, we would have no United States Supreme Court. We'd have no checks and balance at all. Some people might think that's a good thing, but it's Chief Justice Roberts in 1807 in a case called Marbury versus Madison that defined the separation of powers, the three equal branches of government, and the role of the Supreme Court in our civil society. That's why when you go to the Supreme Court in Washington, and I commend everybody to do that, and you should go look at all the core documents that are in Washington of our constitutional republic, the Declaration of Independence, the Bill of Rights, the first 10 amendments, and the Constitution. You should go look at it, and it's awe-inspiring. It may even bring a tear to your eye in this very troubling, trying time. Head over to the Supreme Court for a tour. You'll see not one but two, at least one giant sitting John Marshall right in the middle, and a bust later on. There's a reason for it. He is the Mount Rushmore of constitutional analysis and constitutional scholarship. So when I see, I forgot Marshall presided. Of course, he presided over all the major cases, you know, in the late 1700s, early 1800s. And so They say that in long ago in that trial of Aaron Burr, presided over by Chief Justice Marshall, sitting as the trial judge, no less. This is a treason case where Chief Justice Marshall stepped off of the bench as a appellate judge and was the trial judge, because in cases of treason, they step down and become trial courts. It's very interesting. The probable cause hearing was held in the hall of the House of Delegates in Virginia, the courtroom being too small to accommodate the crush of concerned citizens or interested citizens. From that case of Burr, Aaron Burr, until the present day, the near uniform practice of state and federal courts has been to conduct hearings in open court. This is sort of the basis. When I say in prior hot takes and on Legal AF, we have as a foundation of our society a public justice system where the public has a seat at the table, where people get accused and indicted in public and they clear their name in public, and all major events that happen on the docket are in public. We don't believe in star chambers or secret police yet, or any type of secret tribunal, right? At least not yet. And therefore, the number one component of all of that is that public has a seat at the table. And it all comes from an interpretation of the Constitution and the amendments to the Constitution protecting rights, including the Sixth Amendment and other amendments like the Fourth Amendment and search and seizure and all of that, that got interpreted, got animated, and given life by Chief Justice John Marshall. There's my little side gig teaching you about John Marshall. Chutkan took a look at this and said, you know what? I get your point, but I think most of it is moot. I've resolved it because I released the 165 pages, except for maybe 10% of it where I redacted it to protect the innocent, if you will, to protect witnesses, to balance the equities here. And lastly, she's about to, just as a reminder, on the 17th of October, boy, that's right around the corner, in 3 more days, she is going to publish and put on the public docket the 300 pages plus of additional evidence, witness statements, witness summaries, actual evidence and exhibits. 30 pages of single-space footnotes are all going to be put into the public docket as the appendix to the brief filed by the special counsel in order to solve for the problem created by John Roberts to interpret the superseding indictment against Donald Trump against the immunity decision from July 1st. You can only do that with a fact-based, fact-bound analysis, and that's what we're watching out in public. The reason I say, boy, we're running out of time here, because on the 17th of October, if Donald Trump doesn't finish his exploring litigation options, which is what he told the judge he needed more time to do, and he doesn't get any injunction from anybody, and he hasn't even applied for one, as far as I know, from the Court of Appeals above Judge Chutkan or the Supreme Court, there's going to be a whole tractor trailer worth of new information coming out. And then the media here, the 21 members of the coalition, they can stop worrying about little pieces of black tape here and there on a page, because they're going to have so much to chew on. So are we on here on Legal AF. So this is the countdown. It's hard to believe it's already the 14th. Boy, did time fly. This is already the 14th. He's got 3 more days. He hasn't filed a darn thing in court. Another threat against the judge that which he can't abide, he can't comply with, and nothing he can do to stop it. 2 major filings by the special counsel, and Donald Trump, he has to have his say to try to prove to the American people that he's not a criminal after the election, because he's got nothing to say. When you have 77 witnesses against you, and you've got 300 plus pages, I think this could be a 1,000-page filing by the Department of Justice detailing the corroborating evidence for everything in a 165-page brief. You are DOA. You are dead in the water. You are dead to last rights. That's what I'm going to continue to follow, because that's going to make me very happy and our audience very happy and ecstatic as I analyze another 1,000 pages of documents and information and evidence filed against Donald Trump. We'll do it right here. Look, you're right here already. Legal AF, see that logo? Free subscribe right now. Bring some friends and family. Voting is important on November 5th. Free subscribing to Legal AF MTN is, less important, but I'm encouraging you to do it nonetheless. So until my next hot take, my next Legal AF podcast, all here on this particular homepage, this is Michael Popok, and I am reporting. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.